Amit sir, shall we start?
Yeah, Anjali, we are starting. अंजलि स्टार्ट कर रहे हैं। हाँ मैं कर रहा हूँ, कर रहा हूँ। 1 मिनट दो मेरे को, मैं 1 मिनट प्रेजेंटेशन लोड कर दूँ, मैं करता हूँ। Yeah, Anjali, we can start. If I am audible, na?
Yes.
Amit sir, shall we start now?
Yes, yes, please. अंजलि, मेरा आवाज आ रहा है ना?
Am I audible?
अंजलि, आवाज नहीं आ रही है मेरी?
Now I am audible, sir?
आपकी आवाज आ रही है मेरे को। यस।
Okay, okay. Good afternoon, everyone. I welcome you all to the first session of workshop series 17 on perspective on IBC. Today we have with us Amit Gupta sir as speaker. He will be taking session on the topic practical intricacies involved in CIRP process. Let me briefly introduce Amit sir. Sir is member of ICSI and he is also IP. He is passionately engaged in practice of profession for last 20 years in corporate and right laws and providing out-of-box solution on complex legal and strategic management issues. Sir is science and law graduate and diploma holder in banking and finance from Institute of Chartered Finance Analysts of India. Sir is also chairman of Corporate Law Committee of NIRC and member of Secretarial Standards Board. Sir is keen academician actively serving the profession and has made significant contribution for various publications released by ICSI and as member of Secretarial Standard Board. Now I request Sir to start with his session on topic practical intricacies involved in CIRP process.
Thank you, Anjali, and thank you, ICSI IIP, for organizing this program, this series rather, on this vibrant topic, considering the practical aspects and the intricacies with regard to the insolvency and bankruptcy code. Though we have crossed more than 8 years with regard to the Insolvency and Bankruptcy Code. On 1st December 2016, the law came into effect or was practically implemented. And since then, we have made a long journey and lot of evolution has taken place. We have good or bad experiences from the past, and law has become much more enabling and has strengthened on each count. And many more reforms are already on the cards, and we expect with the mutual cooperation from the insolvency professional and the other pillars of the insolvency and bankruptcy code, we are sure we'll be able to make it our next milestone, as is the expectation of a government. To give you the background and the modality that we are going to have, we'll start with the backdrop. Although majority of the professionals are insolvency professional and they are pretty aware about the insolvency and bankruptcy code. But maybe if there are people who have very recently completed the insolvency and bankruptcy curriculum and they have joined this foray, for benefit of them, we will do some repetitive discussions also, which we have been doing in the past as well, to let them also join our pace and understand as to what we are talking about. Simultaneously, we will be doing the practical difficulties, practical challenges, and the other issues. You are also welcome to interrupt me at any point of time where you want the further discussion on that particular subject. Many of you must have a long experience with regard to different matters, and you may have something to share with your peers and the colleagues. You can stop me there. You can share your learning experience. We all will mutually benefit with each other's learning. To give a insight, this is a very close door group. Only some 16, 17 people are there. So I don't mind even if I am getting interrupted in between, because this is a long series. We are not in a hurry. We will try to discuss nuances one by one, and once we are over with one step, then we will go to the other step. So you are free to stop me at any point of time wherever you feel like we need to discuss it further. Although I'll try to maintain the balance between the people who have joined this for the first time and also the people who have a very fair amount of understanding about the insolvency and bankruptcy code, and they have much more experience than what I have. So we'll try to give a value add to both. To give a start, why insolvency and bankruptcy code is required? Although we all understand the answer, but let us rediscover, because many times the going back to the fundamental, going back to the roots helps us in re-evolving the entire law and the legal framework. So we are trying to do the same thing for insolvency and bankruptcy code. The insolvency and bankruptcy code was evolved because of multiplicity. The problem of multiplicity, the multiplicity of law, the multiplicity of jurisdiction, the multiplicity of forum. These were three multiplicities due to which the government considered it is apt time to introduce single piece of legislation which provides de-stressing to the stressed assets. What was multiplicity? As I mentioned, it was multiplicity of law. You know, there was CIRP, RDDB, SICA, and the Companies Act winding up process, and the normal civil litigation. In addition, Reserve Bank of India guidelines for restructuring of a bad debt was already in place. So if I do the basketing, so as many as 6 different baskets were available at the time when Insolvency and Bankruptcy Code was enacted. That was the reason government was convinced that with these type of multiplicities, perhaps we'll not be able to reach anywhere. And that is what was happening in the last so many decades of time. So government considered it is necessary to remove this multiplicity on account of law. So they enacted Insolvency and Bankruptcy law not as an act but as a code. What is the difference between the act and the code? You understand, the act is a piece of legislation which is focused on one particular aspect. Maybe Companies Act is talking about companies creation and other things. Similarly, income tax is focused on that particular aspect. But when it came to insolvency and bankruptcy, government thought that something akin to CPC and CRPC, Civil Procedure Code and Criminal Procedure Code, we need to evolve something like that. Why something like that? Because CPC deals with anything and everything with regard to civil procedure. Whether it is filing a petition before district court, whether it is before high court, whether it is before Supreme Court, you will get all the answers with regard to nuances of all civil matters in the CPC. Similarly, when you intend to start the criminal prosecution, end-to-end process, end-to-end guidance, end-to-end principle is available in CRPC. So government considered we need to provide end-to-end metrics with regard to insolvency and bankruptcy code also in the form of an insolvency and bankruptcy code. So was that enactment. And it amended simultaneously as many as 12 existing enactment. And there was a 238 section, which was a non-obstante clause. Non-obstante clause means what? Non-obstante clause means the clause which gives a overriding power, which starts with notwithstanding anything contained in any other law for the time being in force, the provisions of insolvency and bankruptcy code will prevail. Section 238 of the IB code very clearly makes it a superpower law over the other laws. There could be some here and there challenges, but intention was very clearly appearing in section 238 that the government wanted to create a super legislation which will override any other law, because the government considered that it is very essence that unless and until we give a superpower to the law, perhaps we will not be able to survive and sustain and achieve any result out of the insolvency and bankruptcy code. Second challenge was the timeline. Existing time frame, whatever were applicable at given point of time, none of the legislation was providing a time-bound processes. Though in certain cases, yes, certain times were mentioned, but the law was not specifically targeting that the resolution has to be completed in this time frame of whatever is the prescription. First time when the insolvency and bankruptcy code, you will see right from the filing of application and its disposal by the adjudicating authority to the finalization of a resolution plan or liquidation, everything is time prescribed. me and you will agree, certain timelines we are not able to adhere. Maybe it is admission of CIRP process before the NCLT, or it is other way. There are cases where we have crossed the timeline of 5 years, 6 years, and resolution plans have not got approved. Be it as it may be, because this was implemented in the country for the first time, there were certain teething troubles due to which we could not reach out to that. But the amendment what government has conceived is going to take care of these bottlenecks as well in times to come. That is what the indication is. Government is conscious of the same, and considering that now 9 years will be getting completed on 1st of December 2025, we will evolve in a new set of regulations where these all troubles will not be there. Comparatively, we'll move away from these problems. Then it also made a significant change, and the change was to detect the stress not on the parameter of a erosion of net worth, as was there in the case of a SICA. We were required to refer the matter to BIFR in case of a industry only if my 100% of net worth was eroded. Though there was a reference that on trigger of 50% erosion, certain disclosures are required to be made. But as such, the BIFR fold start only when 100% net worth was eroded. Now, in many of the cases, it was considered that your net worth erosion may take a bit longer time, whereas your insolvency starts much early. So by the time you are in the shelters of BIFR or any other concerned agency, your assets are already depleted. You have bleeded so much that there is hardly a possibility to recover from that stage. So it is like a cancer. If you go at the first stage, the possibility of recovery is very high. 90 to 99% of the patients will get recovered. If you go at the fourth stage, so the possibility of recovery is just 1 or 2%. All the cases are gone because you have bleeded so much, your assets have depleted so much that there is nothing left for resolution. So they shifted the trigger from net worth erosion to the insolvency. And now what is insolvency? Insolvency is a state where company is not in a position to honor its legitimate dues beyond a prescribed threshold. Any company which is not in a position to honor its legitimate dues at any point of time beyond a threshold will be considered insolvent. Earlier, this threshold was rupees 1 lakh. Post-COVID, March 2020, the threshold was increased to rupees 1 crore. But the parameter remains the same. If any corporate debtor is not in a position to honor this debt liability, which is genuine, of rupees 1 crore or more, that entity will be considered as insolvent, and any financial creditor, operational creditor, or corporate debtor himself can file an application for commencement of CIRP before the adjudicating authority. And adjudicating authority, on hearing the matter, will either admit or reject depending on the merits of the case. Now, how this early detection helps? Because your asset stripping is not there, you are almost in the live condition, your operations are going on. You just might have failed in your sustainability, maybe because of the mismanagement, maybe because of financial crisis, maybe because of technological obsolescence, maybe due to any other reason. So all that is needed, you need some medicine, you need some chemotherapy, you need some isolation and protection so that you can recover from this stage. So the possibility of recovery and revival becomes too high. Similarly, if you detect early, then the possibility of recovery in liquidation, because you will be early liquidated also, because post 1st December 2016, government took a conscious decision that economic wealth of a country should not be put to stake, and any business venture, before its legitimate closure, should be given an opportunity to revive if it is insolvent. With that principle, the Insolvency and Bankruptcy Code was enacted. So there is a compulsory process that has to be undertaken by each insolvent undertaking, which is called corporate insolvency resolution process. Either you will be resolved in 180 days time or such extended period as may be permitted, or you'll have to compulsorily go for liquidation. So that means liquidation is also a time-bound process as far as the trigger of liquidation is concerned. So if you are a steel manufacturing company and you are insolvent today, and if I go 10 years down the line to liquidate your asset, will I get anything? Your machines will be rusted, your operations will be closed, whatever order book you are having will become zero, your credentials for the past 30, 40 years will come to standstill. Nobody will come to rescue. But if you are detected at the stage 1, with the help of technology, with the help of finance, with the help of new management, the unit can be revived. Or if in a year's time, 330 days, which is the maximum time permitted for resolution, you are not likely to be resolved, the adjudicating authority may decide to liquidate. So maybe in a year's time or 2 years' time, your decision to liquidate will arrive. And during that period also, there is an insolvency professional who will take care of these assets in the good health. If they are running concern, he'll continue to be operating, or if they are not, then he will maintain them on as is where is basis. That is the advantage that Insolvency and Bankruptcy Code offers, that by early detection, you will be able to resolve them either by way of a resolution or by way of a liquidation. And liquidation is a last option, because if you see the preamble to the Insolvency and Bankruptcy Code, it does not talk about liquidation. It only talks about resolution. So that is the emphasis that the government has on the resolution process. One more significant drawback in the earlier system was there was no collective platform. Unlike the committee of creditor, where we can come on a common table to discuss the issue and protect the interest of each other. It was noted that the people who were superpower in terms of debt or in terms of anything, they used to control the entire process. Maybe it was a joint lenders forum or anything. And they will dominate the whole process. So the people who were in minority, their interest was likely to be adversely affected. But thankfully, in the Insolvency and Bankruptcy Code, there is a collective platform of a stakeholder in form of a committee of creditor and in form of a stakeholder consultation committee in liquidation, and that take care of the interest of each other. So this law came as a overcoming of the issue of multiplicity of law, of forum, of jurisdiction. You will recall the promoters in the previous era used to do the window shopping. If a CIRP notice come, they will file application before DRT. If DRT does not give any relief, they will go to DRAT. And even if they don't get any relief, they might not hesitate from filing the writ petition before the High Court. And in many of the cases, it was noted that the other interest will be created during that period of time, because in India, the litigation does not move that fast forward. So third party interest will be created, and ultimately, by the time asset goes for recovery or goes for a sale, majority of the value has already been stripped off, that has already been lost. So to prevent that, this law came out with a single forum, that is the adjudicating authority, that is National Company Law Tribunal for a corporate insolvency. And for individual insolvency, Debt Recovery Tribunal was adjudicating authority. Appeal goes to Debt Recovery Appellate Tribunal, and in the case of NCLT, it goes to National Company Law Appellate Tribunal. Both appeal finally goes to Supreme Court. So only two-step process and you arrive at a conclusion, and there is no possibility that you can reach out to any High Court or any Supreme Court directly for the purpose of resolving your stress. It is one single forum, that is the adjudicating authority, who will listen to your matter, who will understand, and who will pass necessary order for whatever relief you are claiming for. So multiplicity of forum and multiplicity of jurisdiction, both issues got resolved with the Insolvency and Bankruptcy Code. This law was enacted with the background of the recommendation of BLRC. Among other recommendations, the major reform was in the form of a recommendation that it will be a creditor in control regime rather than debtor in control. Till the time you are solvent, the corporate debtor is going to sit on the driver's seat. The moment corporate debtor become insolvent and CIRP is triggered, it is supposed to be in the control of a committee of creditor, who is none other than the financial creditor. It is a collective forum of a committee of creditor, so that the interest of all can be protected. Whatever is required, that can be done. So that is the biggest change from the previous regime of SICA, and whatever advantages were there in the SICA, they continues that there will be a moratorium, there will be a restriction on stripping of the assets, protection of asset, all those things are there. So this law essentially is based on 6 fundamental, that it is a consolidated law, it provides for a time-bound process, it provides for the maximization of value of the assets, it promotes the entrepreneurship, it promotes the credit availability, and it balances the interest of all. Now, all other parameter, all other principle may be easily understood. But one principle on which I keep getting the question, how it helps in promotion of entrepreneurship. Answer is very simple. If in a society in which we are living, we are assured that even if I lend unsecured money to anyone, my interest is going to remain protected, because I have a weapon in the form of a insolvency and bankruptcy code, which will detect the insolvency at a very first stage. B, which will endeavor for resolution. C, which is having an orientation to maximize the value of assets for all. Then why at all I will have a apprehension and a fear for lending out my money on an unsecured basis? I will not hesitate. In today's society, people are apprehensive in lending the money on a security also, because they have fear that when the State Bank of India, who has got all security, is not able to realize its money, I am the only unsecured lender. I don't have a wherewithal and expertise like a State Bank of India. My money is going to be duped out. So people are hesitant. I am talking about a scenario where we reach to the stage where people have a full faith in the insolvency and bankruptcy regime, and we do it on the much professional manner, where time is the essence and we are actually able to deliver the result in 180 days of time as was envisaged. And even in the fast track insolvency, the timeline is only 90 days. I think nothing will stop the country from flooding the unsecured money to the society. Everyone has got a money. Everybody wants the investment, good return on the investment. What hesitates, what stops him from doing the investment is only one thing, that apprehension that whether money will be recovered back or not. Everybody wants the interest. Everybody wants the higher return. But people don't have a courage to put forward their money at a risk. But given the scenario when we assure that your value will be maximized, you will be getting maximum of your realizations, then I think we'll come to the perfect society where there will be no dearth of credit availability. If credit availability problem is sorted, India is a country of entrepreneurs. People know how to do the business. People understand they are laborious. And once you give them the carrot and stick story, that we will provide you carrots if you provide good returns, and if you don't, then stick is also there in form of an insolvency and bankruptcy, I think they will come on the right track, and the entrepreneurship will automatically promote. People are not short of idea. People have fantabulous ideas. They have excellent execution capability. What stops them is the availability of money. So that's how the entrepreneurship issue will also be getting sorted. There are certain uniqueness with regard to insolvency and bankruptcy code. It is not just that it is all biased towards the lenders. Everything is not in favor of a lender. There are a lot of checks and balances. Lender is also under the check, and he is under the tremendous pressure while considering the resolution plan. What if I don't approve in a time-bound manner? I am running with the sword of liquidation. You know where the value is going to be much lesser. So he is going to lose money if he don't take decision in a timely manner. It is giving a clarity that it will attract the investor to invest into the distressed assets. Moratorium ensures that everything comes to status quo and corporate debtors stop bleeding further. There is an open platform which provides opportunity to everybody. Whosoever wants to participate, he can participate. No other court has a jurisdiction. Non-obstante clause in section 238. These all things makes this particular law unique. Some of you may make an observation that we have seen that many of the writ petitions are filed. I agree. The jurisdiction of writ was not prohibited, even in the insolvency and bankruptcy regime. But mind you, if you are following the legal matters before the insolvency, you will note that though there was a possibility of filing a writ petition, but what was not permissible was to entertain the insolvency application by any other forum, neither district court, nor civil court, nor high court, nor Supreme Court. Writ jurisdiction can be invoked only on limited ground when it was touching the constitutional wires. If the Constitution of India was getting hitted, through that route somebody can reach out to High Court to vent out his grievance. Nothing beyond that. And in any of these matters, they have not got any interjection where High Court or Supreme Court has decided the matter on merit of insolvency. The matter is remanded back to NCLT as an exclusive jurisdiction for the purpose of deciding the insolvency and bankruptcy petitions. Where the law was challenged, wires of law were challenged, the Supreme Court or High Court has intervened in the writ jurisdiction. But if you see the trend, 2016 it started with innovative when the matter went to Supreme Court. And 2019 it got peaked up, 18-19 it got peaked up with regard to writ. So if at point of time it was 100 a peak, then it started falling down, 100 to 80, 80 to 50, 50 to 30. Then it got stable. Now only minimal, because majority of the issues in the last 8 years have been settled down by the Supreme Court. Now when Apex Court has decided those matters cannot be again going for consideration in a writ jurisdiction unless and until there is something new for consideration. So that's how the law has got settled. Just one more aspect with regard to the law only. What is the intention of the government? That can be clearly seen from the timeline chart. On 14th of May 2014, the government made a swearing ceremony of central government. See the pace. In July, they introduced the concept of BLRC for the purpose of consideration of insolvency law. Composition was made in August. T.K. Vishwanathan was appointed as the chairman in November. And it was given a 1 year time to present a report. And in dot 1 year, in November 2015, the report was received and it was submitted to the Lok Sabha in December. It was referred to a joint committee of Parliament. Parliament Joint Committee submitted its report in April and it was passed in May 2016. It got notified in May 2016 to come into force from 1st of December 2016. So in dot 2 years time, the entire framework from conceptualization to implementation was completed. It took another 6 months time only because by that time the National Company Law Tribunal and Appellate Tribunal were not in force. So government took time to make the selection of the judicial and technical member. And from 1st of December, it was in vogue. Fast track insolvency in 6 months were introduced. And similarly, the personal guarantor to the corporate debtor was also introduced in the 1 year time, that is 2019 December, on same date, they became effective. And from there 2 years time, the pre-packaged insolvency was also notified. So this is a background. Why this background was discussed is basically to give you the understanding, whatever we are going to discuss with regard to the practical difficulties, challenges, nuances. We have to understand from the standpoint what we have just now discussed, how to interpret, how to read. Unless we have a background, what is the seriousness of the government, perhaps we may not appreciate. So the infrastructure that IBBI has created, IBBI as a super regulator, then there are 3 insolvency professional agencies of a Institute of Company Secretaries of India, Chartered Accountant of India, Cost Accountant of India. There are more than 3,500 insolvency professionals and there are more than 90 insolvency professional entities. And there is one national e-governance services, that is the information utility, registered by the Government of India. There are registered valuer organization, registered valuer entities, 14 cities the NCLT is operating with almost 30 benches. There are 2 NCLAT, one head office at New Delhi and one bench functioning at Chennai to deal with the southern part of the India. DRT, DRAT for non-corporate insolvency were envisaged. If you see the layout of the law, it is a very clean law which is divided into 5 parts and each part is self-sufficient. That gives you the ease of reading. If you come to part 1, it is talking about general, which is including the commencement and definition. Part 2 deals with the corporate insolvency. Then there are some 7 chapters, and each chapter deals with the specific part. Chapter 1 deals with definition with regard to the corporate insolvency, in addition to the general definition provided in part 1. Chapter 2 deals with CIRP. Chapter 3 deals with liquidation. Chapter 4 deals with fast track processes. Chapter 5 deals with voluntary liquidation. And chapter 6 deals with the adjudicating authority. And chapter 7 deals with the other offenses and penalty. Similarly, when we come to part 3, it is individual insolvency, and similar classification of a chapter is there also. Then we come to part 4, which is regarding the authority, which is talking about IBBI, which is talking about IPA, which is talking about NESL, which is talking about inspection investigation, and so on. Then there are miscellaneous provision in the part 5. There are pre-packaged insolvency included in the chapter 3A. There are rules and there are regulations. Rules are made by Ministry of Corporate Affairs. Regulations are, of course, made by the Insolvency and Bankruptcy Board of India. This is a broad framework with regard to the Insolvency and Bankruptcy Code, where if it is a corporate insolvency, the adjudicating authority is the National Company Law Tribunal. Appeal goes to National Company Law Appellate Tribunal, and further appeal goes to Supreme Court. Minimum threshold is 1 crore. And if it is a non-corporate, it can be either a partnership firm or it can be a individual. In all cases of a partnership firm, the matter will go to adjudicating authority, who is DRT, Debt Recovery Tribunal. And in case of an individual, it will be divided into 3 parts. One individual who is doing business, one individual who is doing employment, one individual who is a personal guarantor to the corporate debtor. So barring the last category, where you are a PG to CD, in other 2 cases, the jurisdiction will be with the Debt Recovery Tribunal. And the appeal will go to Debt Recovery Appellate Tribunal, and further appeal will go to Supreme Court. However, in the last case, where you are a PG to CD, the matter will be filed before National Company Law Tribunal. That will be the adjudicating authority, and appeal will go to National Company Law Appellate Tribunal, and further appeal will go to Supreme Court. So all matters, whether it is insolvency resolution, liquidation, individual insolvency resolution, bankruptcy, everything will go with these 2 jurisdictions depending on a different case. Now, what is a waterfall mechanism and how it has changed the entire demography of the realization of money? The law has undergone a significant change by way of a section 53, which says about the waterfall mechanism. Now, what is waterfall? It says when your company will be liquidated, the manner in which your realized money will be distributed amongst the stakeholder will be as per section 53. And 53 says it will go to first layer first. Once the first layer is completely saturated, then it will go to the second layer. Once the second layer is fully saturated, it will go to third layer. It is not that something will be going to all layers and equally it will be distributed amongst all. No. It is going to fill the first layer first, then it will go to second layer if there is anything remaining, and then it will go to third and so on. So just assume that you are sitting on a top of a slanted surface and there are 9 holes in that slanted surface. And if you drop a water from the top of the hill, the water has a tendency to go and fill the first hole first. Once the first hole is filled, the water will pour down to the second hole. And then once the second hole is filled, it will pour down to the third hole. So is the insolvency process. Now you replace these holes by the layers provided in section 53. So CIRP cost may be the first hole, the workman dues second hole, employee dues third hole, unsecured financial creditor fourth hole, government dues comes at a fifth hole. Other debt will come as a sixth hole, and then will the seventh and eighth hole as a preference share and the equity shareholder. Now, if you see the old law, that is law prior to insolvency and bankruptcy, the crown debts were getting priority over the other debts. So government was recovering its own money first. Now, because government has changed its psyche, we need not collect a small penny of money. My interest is not in collecting because I am not going to become richer. But if I facilitate the revival of an existing business by providing necessary framework, my country resources will be prevented from its depletion and they will be preserved. So the economic resources which had got created over a period of time will be protected, and that will help the national growth of a country. That was a thought. So with that thought, government put their own dues at a layer 5. So CIRP and liquidation cost is sitting at a top layer. 24 months workman dues and the secured creditor shared the second layer. 12-month employee dues sit at a layer 3 and unsecured financial creditors sit at a layer 4. Government dues comes at a layer 5. Other dues, that is operational creditor, will come at a 6th layer, and if anything remains, then the preference shareholder and then will go to the equity shareholder. Now there is one deviation. If you are a secured creditor, you are given a liberty to choose between two. Either you can go for enforcement of security interest within the prescribed frame of time, or you can relinquish your interest and become part of the waterfall mechanism. Of course, it is a case of a liquidation. When the entity goes into the liquidation, then this kind of option will be given to the secured financial creditor. Advantage is secured financial creditor can decide if a value that is going to be realized out of the proceeds is higher than what he is likely to realize in the waterfall, then he will choose the enforcement of security interest. Otherwise, he will simpliciter relinquish his interest and sit at a layer 2 along with the workman dues. If he does not relinquish, he sits at a layer 4. So if suppose company has realized only 100 rupee and layer 1 and layer 2 dues are 200, this layer 4 will not get a single penny if he decides to enforce the security. Whatever 10 rupee, 20 rupee he can get outside, he can get. But if he relinquish, he will sit at a layer 2 and whatever he will get at a layer 2. So if the value of the asset is 110, he will realize perhaps his full money. That is the decision that the financial creditor has to take when he has to give an option of relinquishment or enforcement. People keep on asking, there are many professionals who don't pursue insolvency profession as a career, who just do the litigation and the other part. I am saying good. There is nothing wrong, because it is not necessary that I should enter into as a insolvency professional only, then I will benefit out of it. There are multiple options available in the insolvency professional with the knowledge of insolvency. You can do advisory, you can do consulting, you can do NCLT appearances, you can do suggestion on the resolution plan. And last but not the least is a deal. In the last 8 years of time, there are thousands of cases which have been resolved and many more have been liquidated. More than 8 lakh crores money have been resolved. And multifold money has been resolved without bringing it to the forum of the NCLT or triggering the CIRP. Now just imagine what people have missed. Some or other professionals must have guided regarding changing the hand or the opportunities available in the insolvency space with regard to deals, with regard to the stressed assets which are slipping into the insolvency, the assets which have gone into liquidation. People have bought the assets at a damn cheap price to the discount of 80%, 90% value. In a 2 years' time, they have revived that unit and they are doing wonders today in last 6 years or 8 years of time. So that is the opportunity that many people have encashed and many people have missed out. So that is one big opportunity in addition to the 5 other opportunities what we have talked about. Then in the case of a pre-packaged insolvency, which was offshoot of a COVID time, government launched this with a very caution. And the caution was because government was very skeptical. Should we give this opportunity or not give this opportunity of a pre-packaged insolvency? Because the unique feature about the pre-packaged insolvency was it was the best of the both world. Judicial and informal. That is out of court. Because people were saying micro small units were having their peculiar problem. And the peculiar problem was because of their inherent nature of their business. The business was centric to certain people. Till the time Mr. X, Mr. Y, Mr. Z was sitting on the table, business was working very smooth. But when attempts were made for insolvency resolution, though resolution have been successful, but post resolution there was hardly any value add, or it was experienced that the businesses are getting failed. And the reason was these micro small units were doing business in a very unstructured format. Unlike Bhushan, unlike Tata, unlike other big players who were resolved, these players were pretty small, and this was person centric. As long as Amit Gupta was sitting over there, people were giving a credit of 3 months for the purpose of supply of goods. The moment they came to know that company has slipped into insolvency and the new resolution applicant has entered into, they were shying away from lending. They were shying away from giving a money on the credit. They were shying away on supply of goods. So all those challenges started post resolution. So government considered that the person who was owner, he should be given one more opportunity by doing a off-court negotiation. Let him go to the bank and the financial creditor to understand what is the optimal level of debt that can be sustained in that industry. He revives, he makes a plan for revival and appoints an insolvency professional, and the person goes to the lender to convince them this is the resolution plan, this is the maximum money that I can pay. And after that, the resolution process was filed before the adjudicating authority. So court virtually was doing a legalization of whatever informal understanding was done between the corporate debtor and lender. And once the consensus was made, the resolution plan was passed. And that plan was binding on all. Only one scenario, one more exception was given. If the committee of creditor consider the value that they are going to fetch out out of this, pre-packaged insolvency is much lesser than what they could otherwise realize by competitive bidding. They could give an option open for a Swiss challenge. So whatever value, say 100 rupee value has been given, they will invite further bids who will challenge the rate of 100. They will say, I will provide 200. Then only the bid will go to the other party. Otherwise, it will remain with the person who was the promoter. The corporate, the promoter can retain that entity. That was the advantage. And it was available only to micro small. There were multiple challenges, so we'll discuss that. Now, let us understand the practical difficulties and challenges with regard to the CIRP process. How the process starts, what are the challenges of a financial creditor, what are the challenges of operational creditor, and likewise. So can we take a break for 5-10 minutes and then we will resume? Anjali, are you there? All right, so we'll break for maybe 10 minutes. This is 3:50. We will resume at 4, right? And we'll take up the remaining part. Just give us 10 minutes. Sorry, my apology. There were few back-to-back calls. I have to attend them, and it got a bit delayed. Let us resume it out from where we left. Just a second. I will share the screen. So now we were on the point who could be the applicant in the CIRP process and how the challenges in the application process are there. So important point that we need to understand how the scheme is framed. It is not really important as to who goes and ring the bell. Point is that if a corporate debtor is insolvent, the bell has to be rung. It can be rung by a financial creditor who has a larger stake, usually, or there could be a operational creditor, or the corporate debtor himself can also ring that bell saying that I am in a insolvency stage where I am not able to repay the legitimate dues of the prescribed threshold, and I am fulfilling all the criteria prescribed by the law for filing this application. You kindly admit me to your ICU for resolution. Once adjudicating authority considers this application, checks whether all parameters are fulfilled, application is in order, by giving the other party an opportunity of filing reply and other things, within 14 days of time, either it will be admitted or it will be rejected. Now, in case of a financial creditor, the default amount is 1 crore, which is in fact for all. There must be a disbursement of debt. There must be occurrence of default. Name of the IRP has to be mentioned in the application. No demand notice is required to be issued. And if there is a record of default from the information utility, that copy also has to be attached. Once this application is completed, the adjudicating authority will serve the letter to corporate debtor. Corporate debtor will appear and will say whatever he has to say, but in majority of the cases, there is nothing much to say. It is an admitted default in majority of the situation because of the financial crisis or so. So there is not much of the challenge, but yes, in few of the matters, the matter has been dragged for almost 5 years, 6 years also. For admission alone, the time which has been prescribed by the adjudicating authority by the IB code for 14 days has taken more than 5 years to complete because of the multiple application before various other forums. Although the law is very supreme, which says that this is a non-obstante provision and only this court has a NCLT has a power to look into and entertain into the application. No other person has the possibility, right? But still, it takes a bit of time to complete that action in certain cases because of the challenges, because of the some orders also or some precedences also where on the pretext of some settlement ongoing, the OTS proposal going on for consideration, or maybe some timeline issues, some technical issues, the financial creditor has missed those timelines. Right? That is the only scenario where there is a possibility of this delay. But generally, otherwise, on the merits, there is not much of the ground which is available in favor of a corporate debtor on the application of a financial creditor. Either default is there or default is not there. Once, in majority of the cases, they already have admitted that yes, because of the financial crisis, I am not able to repay. Kindly give us some time. We will try to regularize the account, or the account is already NPA. So that goes beyond a point that there is much of the point for deliberation. There are few cases that we will see when we will complete this discussion. Application of operational creditor, same amount, 1 crore, existence of debt. But there is a requirement that you have to give at least 10-day demand notice. And if the corporate debtor does not respond, or respond, but he is not able to redress your demand, the operational creditor will have a right to file an application to the adjudicating authority. One difference here, you don't require the name of interim resolution professional. Same manner, the application will be dealt with. Only one exception. If there is a dispute prior to sending of the demand notice, pre-existing dispute, the corporate debtor has a right to plead before the adjudicating authority, my lord, I have not made the payment because of the pre-existing dispute, and because of the pre-existing dispute as per section 8, the application cannot be entertained. If adjudicating authority finds merit in deciding whether genuine dispute exists or not, and if he says that yes, and all other conditions are not fulfilled, or other conditions are also not fulfilled, the application will be rejected. And if application is complete and there is no pre-existing dispute, the application will be admitted. Corporate debtor himself can also file the application. Demand amount remains the same, that is rupees 1 crore. Now, condition that is specified in the law along with section 65 and others, though corporate debtor can file the application through authorized person by proposing the name of the interim resolution professional. Recently there is some change. It will be taken from the panel. The application will be examined by the adjudicating authority and will be admitted, or in many of the cases where intention of the corporate debtor is to take advantage out of CIRP, the NCLT has levied the penalty also. They have rejected the application with a levy of penalty to the tune of 60 odd lakhs in many of the matters where they have found that this was just to seek a protection. Their intention was not to find out a resolution. They were not intending to bring any resolution on the table. It was malified on the part of the corporate debtor to propose that application. What is the process? Notice by adjudicating authority, hearing objections, argument, application will be admitted or rejected. IRP, which is proposed by the financial creditor. In case of operational creditor, one which is by panel, and the corporate debtor also as is proposed or by the panel. IRP will commence and the invitation of public claim will be made. Just interim resolution professional will take over the management of corporate debtor, take over the operations of the bank account. He will take over the control and custody of assets over corporate debtor. Now here comes a practical challenge, and that challenge is there from the last over 8 years of time. Taking over management may not be that difficult. The challenge comes to custody of assets. Now, assets could be a running factory. The assets could be luxury vehicles. Assets could be furniture fixture. It could be plant and machinery. It could be godowns. It could be anything. Because of influence over the local bodies, or because of power, or because of threatenings, or because of manhandlings, in many of the cases we have seen the peaceful position. This part of the handover is not very peaceful. Many times the IRP has to take up police protection, and getting a police protection many times is not easy because the order of adjudicating authority, now it's been almost 8 years, more than 8 years, still the penetration level of understanding of National Company Law Tribunal among the community is very less. So even if you have the order in hand from the adjudicating authority that you are to given a position of the corporate debtor, you are not given the position. The police authority does not come forward to support you. Then maybe you will have to file an application under section 19 to seek necessary direction from the adjudicating authority in favor of the respective district magistrate or the respective judicial persons to help you out and offer necessary assistance and protection for the purpose of seeking necessary position. So each case will have its own challenges. Each case will have its own merits. Many times the promoter is absconding. You are not given any clue as to where the assets are lying. Few movable assets may be already siphoned off. Few luxury vehicles could already be siphoned off, or they are beyond your control and position. In many cases, we are not able to take possession of those assets even 3 years after the commencement of the CIRP. These are all challenges. The biggest challenge comes in respect of complying with the control and custody of assets of the corporate debtor. So we have already flagged this issue before the IBBI at every forum and at every channel wherever the opportunity comes, but they also have a little challenge. The best way is to create education and awareness among the society. If a police department and the concerned administration of the local district is educated on the insolvency resolution process, he will immediately understand, okay, all right, this is the order from adjudicating authority, and to ensure that the takeover happens in a peaceful manner, then he will offer his services. This situation was not there with the official liquidator. Official liquidator also has to take control and position when we were doing a winding up in the old law. Because the official liquidator was appointed by Honorable High Court. So he was carrying a direction of High Court. Direction of High Court was well regarded and he was considered to be an officer of the court for the matter. Although the IRP is also an officer of the court, but many a time he is not given the due respect due to which these kind of challenges comes. Secondly, the suspended board of director. Section 17 very clearly says that the power of the board of director is suspended and will be vested with the interim resolution professional. Now, challenge is that he does not really understand this whole matter. Because till yesterday, he was one who was in control. He could not understand how all of a sudden the entire power is shifted from him to a new guy who is 35, 40 years of age or maybe 50 years of age. He is coming to me and say that your board powers are suspended. Now I will run the show. It takes time. Over a period of time only he will understand. Maybe section 19 application may be required. So there will always be a non-cooperation coming from his side. Whereas the interim resolution professional is working in his best interest for the purpose of resolution. His corporate debtor entity which is bleeding is going to be revived. Of course, he may not remain in position. He may not remain the promoter. Someone else will remain. But he in any which case has lost all the value. He has lost all the trust. So that is why this situation is there. The early he reconcile, early he cooperate, I think best will be the resolution. But unfortunately, that does not happen. And it also depends on the art of the interim resolution professional as to how he communicate all that to the ex-management with regard to that responsibility, with regard to duty, with regard to the role that he has to play and seek his cooperation. In many of the cases, we have seen this works, but in many of the cases, this really does not work also. All officers and management will report to IRP. He has a duty to operate it as a going concern on the directions of the committee of creditor. He has a responsibility to collect all the information relating to assets, finance, operations, CD, and receive and collect all the claims submitted by creditors. So next challenge comes with regard to the collation of claims. You are appointed as an interim resolution professional. You don't know about history, geography of the corporate debtor. But you are given a claim from the third party, which he claims that he has provided some services or he has provided some money. You are not in access to the books of accounts of a company. You don't know whether goods have been supplied or not. You don't know how genuine that claim is. You have an apprehension that these claims might be forged also, because I don't have a wherewithal. In the system, people are aware about all that challenges. So there could be a possibility that people might make a false claims also. And they may put a pressure by filing an application before adjudicating authority and so on. It may look very genuine in many of the cases, but you have to collate all the claims. You have to try to find out the information, whatever is available from the corporate debtor, books of accounts and the other records. At least ask all the information which is required for the purpose of collation of the claim. At the stage of IRP, your duty is to only collate the claim. You're not required to go for meticulous verification and authenticity. Collation means whatever he has submitted, you are collating from the records what has been submitted by himself, whatever record has been there in the information utility, whatever record is in the corporate debtor, or any other secondary record of the document, whatever is available with the committee of creditor. Basis that you will collate and you will make a list of creditor. Basis that you will constitute the committee of creditor and you will monitor the assets and manage the operations until RP is appointed by the committee of creditor. During the period from the admission of CIRP to the stage of approval of resolution plan or discharge of corporate debtor, the moratorium will be there. Moratorium means the institution of suit, continuation of pending suit, proceeding against the corporate debtor will be prohibited, including execution of any judgment, decree, order of any court, tribunal, arbitration authority, any transfer, encumbrance, alienation, disposal of by the corporate debtor any of the assets or legal right or beneficial interest therein, any action to foreclose, recover any security interest created by the corporate debtor in respect of the property, including any action on account of SARFACI, recovery of any property by owner or lessor where such property is occupied or is in possession of the corporate debtor. However, the supply of essential goods, services to the corporate debtor. What is the essential good? Say I am a manufacturer, I am a steel manufacturer. So somebody cannot come and say because your past dues have not been paid, so your electricity will be cut. Because I have to run it as a going concern. No matter, your claim will be considered on merit, but still you have to continue the operations. That is a protection available. Maybe I know that my money past has been lost. I am assured of a new money, but in many cases, even new money may not come. I don't know whether there is an asset to recover or not, whether the resolution will happen or not. There may be cases where even the liquidation cost is not recovered. That is a challenge, practical challenge. I am doing a couple of insolvency matter where fraud is involved. From day one, we know that there is no asset, but still the matter is admitted. And once the matter is admitted, CIRP is going on. The bare minimal cost of operations where you have nothing to sell off will be your expenses for publication, will be your other expenses, right? In some cases, the financial creditor may pay it off. There are judgments in favor which says that until the liquidation, until the resolution, it will be pooling off, the money will be pooled off by the committee of creditor in the proportion of their claim. But many a times you have to struggle to file the application before the adjudicating authority in doing that also. And the worst are those fraud cases where you know there is nothing to resolve. but still the matter is going on. And at the end, when the liquidation happened, the resolution professional end up paying the bare minimal expenses with regard to the newspaper publication, with regard to the other expenses, with regard to the expression of interest, with regard to the other thing, whatever legal and other expenses that the IRP incurs. Is a practical challenge. But we have no option, because once the process is admitted and you are appointed, there is no via. You can file the application, but that also costs. And no guarantee that your matter will be discharged, because the process is set in motion. Only legal recourse will come, bring it to the end. That is the challenge, biggest challenge. So my request to IBBI, we have discussed it time and again, that we should be able to have a vindication. Either we should be given the opportunity to file an application before IBBI, where IBBI take a cognizance of the matter and basis that decides that this matter is a fraud and some investigation should be ordered and the CIRP process should be terminated. But so far, not much has been done, so that is a challenge as of now. Regulation 32 also defines the essential goods and services. Electricity, water, telecom, information technology, to the extent they are a direct input for the output produced by the company. If you see the moratorium during CIRP, and similar moratorium is there in the liquidation, but there is a small difference. Whereas during CIRP, the moratorium, the all suits and proceedings which were going on come to the halt and no new suit can be filed. Whereas in liquidation, all matters which were going on prior to commencement of CIRP revives. You can pursue before the respective forum. However, filing of a new suit is prohibited. No new suit can be filed. So all those matters which got stopped on commencement of CIRP gets revived at the time of liquidation and can be perused. Rest all process more or less in the moratorium remains the same. Now in committee of creditor, the IRP has to identify the financial creditor and constitute the creditor committee excluding the related party. And basis that if there are any operational creditor whose aggregate debt is 10% of the total debt, are allowed to attend the meeting. But they don't have any voting power. However, if there are no financial creditor, top 18 operational creditor will form the committee of creditor. And in that case, they will have a voting right. They will become a member of a committee of creditor, but not in the other cases. Each decision of the creditor committee requires 51% majority vote unless otherwise provided in the code. But most important decisions require 66% majority. Like the acceptance of resolution plan, withdrawal requires even higher percentage, change in management, disposal of assets, whatever is the important decision will be going with the 66% majority and others will go with the 51% majority. Decision of committee of creditor are binding on the corporate debtor and all creditor. In first meeting, with 66% majority vote, either the same IRP is appointed as a RP or a new person is appointed as a RP. There are few matters which will require the approval of committee of creditor. If you want to raise any interim finance in excess to the amount what COC has decided, if you want to create any charge on the assets of a corporate debtor, if you want to change the capital structure, if you want to issue additional security, if you want to create a new class of security, if you want to make any buyback, if you want to make any redemption, if you want to record any change in the ownership of the corporate debtor, or if you want to give any instruction to bank maintaining accounts of the corporate debtor for a debit transaction from any account in excess of the amount, whatever is decided, or if you undertake any related party transaction, or if you amend any constitutional document, or if you make a delegation of authority to any other person, if you dispose of or permit to dispose of any shares by the shareholder, or change in the shareholding pattern, or change in the management, or if you want to appoint any personnel on the contract, or if you want to appoint any statutory auditor, then you require the approval of committee of creditor. There are certain actions which require 66% majority. For extension of CIRP by 90 days, that is 180 days plus 90 days plus 90 days. For appointment of RP, for replacement of resolution professional, for approval of committee of creditor, for various actions under section 28. For approval of resolution plan, you require the approval of 66%. For deciding that now you know that nothing is there for resolution, you are deciding for filing liquidation application, then you need to have a 66% majority vote. There are matters which requires only 51%. Approval of eligibility criteria, bid evaluation matrix, authorizing any person to attend the meeting, ratification of the public announcement expenses, reduction in notice period, modification of voting share, sale of unencumbered assets, ratification of expenses, approval of resolution professional fees, RP and amount payable to professional appointed by RP, modification of expression of interest, bid evaluation, and so on. There was a fast track process also introduced, but because this has not been very effective, I think we will not get involved in this discussion. We will utilize this time for the other beneficial purposes. These are the model timeline, and appreciate the biggest challenge of an insolvency professional is that at a time he may have to wear as many as 6 to 8 hats, having a different roles. One role is that he has to keep the entity as a going concern. Now he is a non-technical background person. He does not know how to run automobile industry. But still he is a made CEO of that automobile company and he has to operate that. He has to deal with the supplier of goods also, and he has to deal with the buyer of goods also, without knowing anything about the industry. That is the challenge number one. Challenge number two, he has to run the process within the timeline, whatever are prescribed. My model timeline prescribes that you have to complete the entire process in a manner that it completes in 180 days time. Exception is that you may get extended time. But even then, in 270 or 330 days time, you have to complete. So it's a time-bound exercise. So you have to constantly be vigilant about the CIRP process. So second hat that you are wearing is with respect to meeting the timeline and adherences. Third challenge is with regard to handling the committee of creditor. Now your committee of creditor may have a diverse people. There may be 5 people, one person is having, nobody is having a majority, but someone is having highest number of share, maybe 33%. He is still alone not sufficient, or there may be cases where one person is holding 70% and there are 5%, 6 people. But those people are also having a challenge. The majority person who is having 70% wants to run the CIRP to the detriment of the other 5% holder. You have to balance the interest. You have to do all the compliances as per applicable law. That is another hat. If you are a listed entity, this compliance burden is even more. And challenge is that you don't have a login ID with regard to any of the authority, whether it is stock exchange, whether it is income tax, whether it is GST, all you have to obtain afresh or you have to retrieve. You don't know about the past, but you have to file the returns. Your balance sheets are not prepared, but you have to prepare the balance sheet and file the returns. Your payment to the auditor has not been done, but you have to get the accounts audited. You have the obligations to fulfill, but you don't have the resources to. You are begging for doing a favor by providing the services on credit. At times, people may not agree to the same. And you are helpless in those situations where your timeline is getting breached and you are not having onboarded with certain professional for certain timelines. At the same time, you have to do the job of an investigator also. That means you have to file the PUFE application in a prescribed frame of time. And the last hat is with regard to the invitation of expression of interest for the resolution plan, evaluation of the resolution plan, checking the requirement of regulation section 31, whether they meet all the requirements. And then you have to file the application, and if it is not going forward, then calling a meeting of committee of creditor to propose for liquidation. So you have a multiple role. As you see, you at times will be wearing 7 to 8 hats, and simultaneously you will be doing the different activities. It is not just that whatever IBC law has prescribed that you are just keeping on doing and your process will run through. You will start from a funnel. Now you can come out. That is the only option. You cannot go back from the tunnel. There is no reverse. You cannot come out by the door from where you have entered, except in one scenario where the process is terminated on appeal or it has been terminated on withdrawal application. So if a CIRP commenced on T date, public announcement is made on T+3, claims are submitted on T+14. Of course, the claim can be submitted as late as the invitation for expression of interest. Verification of claim has to be done 21 days. If there is an authorized representative to be appointed within +2 days, you will submit a report to the adjudicating authority for constitution of committee of creditor in +2 days, that is T+23, and first meeting of committee of creditor has to take place within 30 days. Appointment of RP will also be done within 30 days. Now, challenge is that from a committee of creditor, it is stated that there are 4 pillars on which the insolvency and bankruptcy code is based on. First pillar is insolvency professional. Second pillar is adjudicating authority. Third pillar is IBBI. And fourth pillar is committee of creditor. So despite committee of creditor is one of the pillar and has the largest skin in the game, unfortunately, last 8-year experience suggests that is the last agency to come forward for the support to the process. They may have their own challenges, but enough time has passed. It's more than 8 years. But they are not able to nominate a person who has the authority to take appropriate decision. Maybe it is their own internal challenge that at every meeting, there are so many CIRP processes going on parallelly. They are not able to nominate the person with authority who has the capability to take decision then and there in the meeting of committee of creditor. So the biggest challenge of our ERP starts from the committee of creditor itself. And fallacy is that he has to work in close coordination with the committee of creditor. He cannot make committee of creditor angry every day. There cannot be a bone of discontention between the RP and the committee of creditor or the financial creditor. There has to be a harmony. How harmony to be achieved when I am getting frustrated that you are not giving me a decision? You are saying wait for 1 week for starting the voting. Whereas law mandates me that I have to start the voting in a given frame of time. My first default start from there and I'm helpless. I am writing emails, but he's not listening to it. What to do? He is required to give certain approvals. Maybe replacement of IRP by another RP. I have seen decision pending before the committee of creditor for the more than a year's time. IRP continues to function without any support. RP appointment is done by the committee of creditor, which is supposed to be done in the first meeting, is done after several meetings because decision has not been taken. Committee of creditor is ultimate authority to approve the CIRP cost. Now you decide, you have a red alert, red flag, that you are suspecting some PUF transaction. And you need to appoint a transaction auditor. You have invited the expression of interest. You have got all authority to approve the transaction auditor. But still you want to take the committee of creditor into the confidence. Why? To avoid the embarrassment. With regard, tomorrow the committee of creditors should not disallow the expenses on account of transaction auditor, which puts you in the embarrassing situation before the transaction auditor that his cost is not approved. Although there are ways and means, you can file the application before the adjudicating authority, and adjudicating authority can in turn approve. But that remains a challenge, that your process is disturbed. You are not there to do all that. You are there for resolution. But your energy is getting wasted for what? For the inactions or indecisions by the part of the committee of creditor at times. You are required to appoint some professionals for support, because you are working as a CEO of an automobile company. Though you have a power to appoint the professionals for keeping the entity as an ongoing, again, expenses are part of CIRP cost, so it will be approved by the committee of creditors. Again, you are challenged. You don't know the technicalities of the operation. Your operations are getting suffered, but you are helpless. At the same time, when you are intending to move any application, or you are asking the committee of creditor to contribute in the proportion of their claim, it is delayed. And that delay causes the delay of the CIRP process. And that is the reason over the last 8 years of time, people have considered that this IBC is losing its shine because of its delay. And delay is primarily not because of the IRP's inaction in majority of the cases, but because of the delays primarily on the part of the other, that is maybe including the committee of creditor. So that is where we need to look into and work upon. So after appointment of RP by the adjudicating authority, RP will start his work, but until he is appointed, IRP has to perform his duties as a RP. Appointment of valuer has to be done by 47th day. Now, parallelly, if there is any withdrawal application filed, within 7 days, it has to be placed before the committee of creditor. And RP has to file the application within 10 days before the adjudicating authority. Now, parallelly, one more action. In T plus 75 days, he has to form an opinion whether there is any preferential or other transaction. Within 40 days time, he has to determine whether there are PUF transactions. And he gets another 20 days time to file that application. That means within 135 days, he has to complete the entire process and he has to file that application. So all these things are going parallelly. Now, let us come back to his original objective. His original objective was to resolve. So, parallelly, he has to start working on preparation of information memorandum. Now, he has no data. Promoter is absconding. X management is non-cooperative. Books of accounts are under a software which has expired, where password is not available. Even if you have accessed the computer, it is a blank computer, all data erased. Now you are struggling in recovery of data through some IT expert. What not you might have to undergo, you can't just imagine. You might have to do everything in a given case for the purpose of meeting different timeline, meeting different stakeholder expectation. You have to publish Form G for inviting the expression of interest. T plus 75. You have to publish the list of provisional resolution applicant, prospective resolution applicant. You have to publish final list. You have to invite the objection. You have to finalize the final list. You have to prepare the evaluation matrix. You have to invite the resolution plan. 1 plus 35, 135 days. You have to approve the resolution plan by close of 135th day by the committee of creditor. Then you have to file it before the adjudicating authority in 165 days. And adjudicating authority approves the plan in 180 days. Appeal can be filed on a very limited ground in 30 plus extended period of 15 days on a limited ground that plan is in contravention to law or there are material irregularities by RP during the CIRP process, or the debt owned by the operational creditor has not been dealt by the RP as per insolvency and bankruptcy code, or plan does not pay CIRP cost as per insolvency. So these are the only ground on which the appeal can fly. Otherwise, there is no option by which you can file the appeal. This is a brief snapshot just for a limited understanding with regard to the pre-packaged. Almost the process runs same. Responsibilities remains the same. But yes, just to give you the bird's eye view how the pre-packaged insolvency works, there is a pre-admission and moratorium. In pre-admission, it is a mutual negotiation between the corporate debtor and the financial creditor, where updated list of claim will be prepared, information memorandum will be prepared, shareholder resolution will be prepared, consent of majority of unrelated financial creditor will be there, base resolution plan will be prepared, identification of a insolvency professional who will work as a RP, and application will be required to be filed for admission before the adjudicating authority. Application filed on T0 date. If our adjudicating authority admit, the insolvency process commences. RP has to constitute the committee of creditor in 7 days. Corporate debtor has to submit a base plan. Base plan may impair operational creditor, yes or no. If yes, the commercials of base plans are disclosed and alternate plans are invited. and best alternative plan is selected on the formula. And if there is no impairment, committee of creditor may approve the base plan, and plan submitted to adjudicating authority gets approval in T+90. Pre-pack insolvency closes with the resolution. Or alternatively, where best alternate plan is selected, where thresholds are there, it should be best by X percentage or Y percentage, whatever the case may be, and then the matter goes to the committee of creditor. Committee of creditor will either approve or reject. Once the plan is approved, the pre-pack insolvency resolution will come to an end. Now, challenges we have seen with regard to the different hats that he has to wear, and each hat has got its own challenge that we have discussed also. There are certain powers given to the RP in terms of the IB code. He has the authority to access the books of account, records, and other relevant documents available with the government authority, statutory auditor, accountant, and he has a power to take control and custody of any assets. This both have discussed. He can file 19(2) application. If there is no cooperation, even the person has resigned, even then as an ex-management, he has a power to call the person to support. He has similar powers given as a liquidator. All the assets of a corporate debtor, if attached by the government authority against the tax dues, will be released in favor of the RP or liquidator, maybe bank account, maybe immovable property. However, if the assets are already realized, income tax department has attached your asset and has liquidated and disposed of, settled it against the dues, then you cannot. But in other cases, you can do that. He will be responsible for complying with the law of the land. He will comply with all provisions during CIRP vis-a-vis TDS, TCS, GST, income tax, ROC, SEBI. He will take over the management of a corporate debtor. He will be vested with the powers of the board of director of the corporate debtor. He will have access to information from the third party to the extent they are relevant for CIRP. Maybe depository, maybe professional advisor, information utility, other registries, keeping ownership record, members, promoters, partners, directors, JV partner, contractual counterparties of the corporate debtor. Bank, financial institutions maintaining the account of corporate debtor will act on the instructions of RP. Bank account operations will be under the control of RP. Please don't misunderstand that the checkbook has to be essentially signed by the RP. There is no such requirement. It's a control. As a RP, I may not sign any check. I may ask the managing director or a manager or accountant to sign the check and continue to sign the check. Whereas approval authority for those payments will remain with RP. I will approve, then only the check will be signed. So if you are able to build that mechanism and control, then very well you can avoid signing those checks also. There is no compulsion that you have to compulsorily sign. You have to collect the information relating to assets, finances, and operations of the CD. You have to receive, collate, and verify all the claims submitted by the creditor, monitor the asset, manage operations until the RP is appointed, take control and custody of the asset. This we have discussed. You have to preserve and protect the assets of CD. That is again where the challenge comes. You have not received the custody. You have not received the control. But you are obligated to preserve and protect. So first step for preservation and protection starts to take the custody. Tomorrow you might be questioned that you have unduly favored the corporate debtor and the ex-management by not taking control of their luxury vehicles. You were in corruption. Why you have not done so? That is a challenge that you might have to prove. So is the case with the PUF application. You have a suspicion. You have appointed the transaction auditor. Transaction auditor keeps asking for information basis which he can conclude. In my career, I have defended as many as 8 PUF applications. And my strike rate is 100%, that I am successful in defending the PUF application. Not because I have got some extraordinary talent, only because the persons who have filed these PUF application, they could not complete their homework. The transaction audit report is inconclusive. The findings what the person has made are like we are not able to conclude whether the fraud has taken place or not. We require more data. Kindly direct the CD to provide us the data. If you yourself are inconclusive, in what manner you will be able to stand before the adjudicating authority to get a favorable order? I am not saying it is a fault of RP. It is a fault of a situation. Had I been also in the same situation, I might not be in a position to extract anything better. Challenge is that I am not in a position to access the books of accounts. From where I will prove the fraud? I need to evidence before the adjudicating authority regarding the fraud. Now we have to evolve. Challenge is to evolve the transaction auditor and the RP, that with the limited information, how you can prove before the adjudicating authority regarding the PUF transaction. The moment you become successful, your role becomes worthy. You have a hat to represent before the third parties on behalf of the CD. You may have an obligation to raise interim finance. You may have an obligation to appoint accountant, legal, other professional, valuer, transaction auditor. I'll share you one of the example. In one of the case, we called off the annual general meeting. And because the promoter was holding majority, he voted against. We were having no option but to file the application before the adjudicating authority to disallow the votes of that group of shareholder, because their intent was nullified. Either they should come up with the objection to the financial statement, which they have not. They simpliciter, because as a RP, I don't have a power to adapt the balance sheet. The certain powers will continue to be exercised by the shareholders, by the regulator. If shareholder don't approve, I am not in a position to appoint the statutory auditor. I am not in a position to hold the general meeting, adopt the financial statement. So my defaults are bound to happen if I am not getting the cooperation from the other party. And last but not the least, you have a continuous obligation to maintain the updated list of claims. So you will keep getting the claims. You will keep updating the same on a every moment basis. You have a chairman of a committee of creditor. And this is a beauty also, how the balancing in the insolvency and bankruptcy code has been done between the powers of various stakeholders. Committee of creditor who has got all the voting power is not having any right to appoint chairman. Right to appoint chairman or the chairman of the meeting is insolvency professional, one who has no voting right, but he is 100% aware about the running of the CIRP process. He has to prepare the information memorandum. He is to invite lender, investors, other person to put forward their resolution plan. He has to put resolution plan for consideration. He has to observe, find and determine the avoidance transaction. Next comes who can be the resolution applicant. He could be anyone except those disqualified in 29A. Who are disqualified? The people who are provided in section 29A, who is in discharge insolvent, who is a willful defaulter, whose account is NPA, whose disqualification as a director is there, who has been debarred by SEBI, who has been guaranteed to the loan where account is NPA, or is subjected to disability. It's a very long case and your connected persons also can be disqualified. So you can also be disqualified through that. A long range. There is no limit how many resolution plans can come. How many number of modifications to the resolution plan can be done. He has to examine each and every plan to see whether that meets the requirement of the section 31. Last part, after that we will give the window for discussion on the issues what we have flagged. If a resolution happens, then all right. Liquidation can happen in 4 conditions only. A, situation where committee of creditor has taken decision with 66% of majority during CIRP that there is no possibility of resolution, kindly liquidate. Or in 180 days, no resolution plan approved, automatically you are triggered for liquidation. Or you have approved the resolution plan, but adjudicating authority reject. Or last situation where the resolution plan is approved, is set for implementation, but the resolution applicant fails to comply, then also the liquidation can happen. NCLT has to pass the order and liquidator has to form a liquidation state and will be fiduciary for benefit of all creditors. He will liquidate the estate and will distribute in the manner provided in the section 53, and moratorium we have already discussed. Moratorium provisions will come into picture. Now, challenge of the liquidation biggest is, as I discussed, in moratorium, your all existing cases come to a life. Here comes a challenge. I might have completed this whole process in a year's time, Now, real struggle starts from there, in liquidating the asset, in realizing the proceeds, in distributing the proceeds, and biggest one is cleaning up the legal cases. They might be before the different authorities. There may be income tax, there may be GST, there may be commercial litigation, there may be other statutory authorities issue. Unless those issues are closed, you cannot file the application for dissolution. That is the last challenge which I wanted to flag. And once everything is done, you will be filing the application for the purpose of dissolution, and the application will be considered and the order will be passed. We have completed one part of CIRP and its challenges with regard to different stages, with regard to different processes, with regard to different heads, with regard to all not. Next step, we will be taking it forward from here for the purpose of individual insolvency and the nitty-gritties of maybe claims specifically, maybe for resolution plan specifically, maybe the committee of creditor and the other series. This is a webinar series, and we'll cover up other aspects. Now, floor is all open. We can take up the questions which you might have with regard to the discussion what we have in this session. Please, over to you. Any questions from anyone? Anjali, are you there?
Yes, sir.
Yeah, I'm done with. Is there any question? So we may ask the participant to unmute and they can ask the question.
Yes. Participants, are there any questions? Well, I think there are no questions.
All right, so we may close the discussion for now, and then we can you can take it forward from here now for the subsequent series. Thank you all for your time and patience for listening me for the last 3 hours. If there are still any question, my connect number will be there with Anjali. You can take or in my presentation, and we can discuss it out at any point of time. All right, thank you.
Thank you very much, sir, for giving your valuable time and sharing your learning and experience. Sir, please share the PPT for both
I
the sessions.